Hi, welcome everyone. This is Lucas Garritson. I welcome everyone on behalf of Telugu NRI Radio and Burgos Garritson Law. This is our weekly immigration show. I know we've had a hiatus for a couple weeks, and want to welcome everyone back. Hope everyone's had a conclusion to a summer, enjoyed their summer vacations and everything. While we're getting ready for fall and winter here. A couple of notes, some updates since we last spoke. You know, we had the new fiscal year began with the government. We've been seeing quite a few GC approvals, most notably people at EB2 with priority dates in the 2011 range, maybe early 2012. So hopefully this trend continues and we continue seeing more and more approvals coming up here in the next few weeks, few months. And hopefully that backlog is addressed, because as we all know, this next year, we're going to have quite a few extra visas allocated for EB. And hopefully we can get a lot of this EB backlog taken care of. Also on a secondary note, we've been extremely busy processing H4 EAD litigation cases for delays and where EADs are not issued. We've handled cases anywhere from 1 month pending, 1 year pending EADs all the way up to maybe 2.5 months in that window. So we've seen a lot of positive results with that. We hope to see remedy with this issue with slow processing times here soon. This is something I think USCIS has even addressed on their website, on their Twitter account, saying that, customer service is of utmost importance to them. I don't know how effective of a statement that is or how true of a statement that might be, but according to their website and their official spokesperson, they're issuing statements saying that, they want to improve their customer service, want to improve their processing times. And, as far as what plan they've implemented or what plan they're going to follow to improve these pain points, we don't know at this time. And hopefully these provisions are addressed and fixed here soon. Also, on another point, we have, interesting news about the immigration bill, and it's been somewhat of a issue going back and forth over the past couple of weeks, maybe the past couple of months, with the new infrastructure plan. What the parliamentarian in the Senate will accept or reject, which is pretty much everything lately has been rejected. And I know, there's been a lot of issues coming up here, not only for budget reconciliation, but also for this infrastructure plan. And we hope and would expect some action be taken impacting immigration. This is really the best opportunity we have at the moment in the most recent history or in our near future for something like this to happen. Having said that, I think, we've had some expectations with the new visa bulletin, pretty much as expected. There's not much movement for both October and what we know coming up for November. So we're expecting possibly December, January bulletin. We're going to start seeing aggressive movements again. But as a reminder, we want to remind everyone that USCIS is not going to implement massive change, or the State Department, much like what happened last year. So the good news is there's been plenty of family-based slots reallocated to employment-based, which would be 150% from last year, in addition to the normal slots. So we're hoping it will help reduce this backlog that we have for EB cases, and also that we'll have a more efficient processing of these cases once you're able to file. It's been somewhat of a nightmare this past year with the circumstances created by the 100,000 extra cases filed with USCIS. Obviously, we've spoken about that at length in the past, where we had delays getting receipts for 2 or 3 months. I think even right now, a lot of people still have not received the GC EAD or advanced parole. Hopefully that process will continue, moving effectively so more people can have those GC EADs and advanced parole in hand. Other than that, I'd like to also welcome co-host Venkat, if he can join us and maybe update us on current events of what he'd like to discuss. And as always, anyone who's watching our show or listening, we'd like for you to participate. This is a service for the community, so any information or questions you might have or points you would like to discuss or bring up, please, this is the forum for that. We'd like to encourage that whenever possible. Hi, Venkat, how are you doing?
Hi, Lucas. Yeah, I'm doing good. Hope you are doing good. So yes, last couple of weeks we did not do the show due to some reasons, and so yeah, as we know, it means we come up the update news. Maybe let me ask about the visa bulletin. You said this maybe November, December, or January will go to the aggressive. So as of now, EB2 is the September 1st, 2011, and EB3 is the January 1st, 2014. Particularly in EB3, so most of it means we know that the filing date went to December 31st, 2014. So most of the people are waiting for whoever January 1st, 2014 to December 2014. How much move forward in coming months? Maybe not December, January, but end of the fiscal year. We'll get everyone to reach out to December 31st, 2014 as a final action date, do you think? Or did you hear any information, your ILA group and your community, your group, attorney group, or do you have any more updates on this one?
I think, as far as actual dates or predictions like that, I think we're just working in, educated guesses. Now, what I can go back over the process of is to determine how fast or how much the dates move. We know from public information how many I-140s have been approved for people who are from a certain country within a certain visa category based upon priority date. So if I know there's been 3 cases in the past 5 years with I-140s with this state, this state, this state for this one person, it will show up as 3 individual I-140s with this priority date. USCIS would have access to know that the same A number's been used on all 3 or what it means is the same person. So what might be public data in the sense giving us an idea of how many cases have been filed, what we don't know is individually how many of these cases are there for each individual person. Now, what does this mean? Well, the dates will move, and depending on how many people might have downgraded this past year, or let's say there's no downgrade. Let's just use a basic example saying that my I-140 has priority date of June 2011, and I have 2 cases filed. I have an original employer, and then I have a ported I-140 with a second employer. Now, it's going to reflect statistically as there's 2 I-140s with EB2 in the sense of in the country category, in the visa category, show it reflecting that. But it's not going to reflect that these 2 I-140s are associated with me. Obviously, we don't want everyone's public or private information out in the public. If you can imagine, people would steal all sorts of information if we had that. So what we would want to look at is to see what the data is updated with. So if my GC is approved, obviously USCIS is going to know that my A number associated with these cases is no longer valid for these I-140s, because as soon as I have my GC, there's no need for I-140 for my duplicate applications or with different employers, et cetera, et cetera. So as that moves, we're going to see a lot of people this past year who've received GC, where USCIS is going to, quote unquote, recalibrate their system to see how far they will move. Now, I think the one thing you'll see is you're not going to see aggressive movement month to month. You'll see it in the batches of, maybe 2 or 3 months at a time. You'll see consistent movement. This might mean, we might see an additional extra 20 to 25,000 cases filed, early next year, or the opportunity for those to be filed with USCIS. We don't want to repeat the problems we had last year, where we see 100,000 plus cases filed, and there's such extensive delay that it's really hurts more than it helps to process, to move the dates that fast.
Yeah, that's true. So here the question is, September last week, most of the applicants are expected USCIS will adjudicate it as much of as applications are issuing the green card. Surprisingly, we didn't see any progress even any green cards issued, especially last Friday and Thursday and Friday, end of the year. So we know that it was almost 80,000 green card numbers got wasted, right? So do you have any information? Just we hear something about the USCIS is doing some kind of statistics, as you said, is collecting the information to improve the process and issuing the green card. At the same time, let's say maybe if any application is cleared and ready to adjudicate it, did USCIS allocated the visa number for that one, but did not issue it? But is there any possibility to assign the numbers and keep the bucket? Maybe they will adjudicate it in the next couple of weeks, or maybe next one month or 2 months.
Yeah, as far as like maintaining the visas to not be wasted, I mean, I think President Biden and a few congressional leaders had the opportunity to definitely put some kind of a stopgap measure in there to protect these precious visas from being wasted. And, unfortunately, nothing was done. So whatever was unused is unused. And now we have to rely on fiscal year 2022 for the visa numbers. Now, I wouldn't say that all visas were not processed. We've had quite a few, I'd say personally with our office, we had 4 or 5 approvals late last week because of, trying to go through. And we have to remember when these cases are being processed, if you have a 2012 or 13 priority date, obviously you're not going to be receiving GC right now. It's a FIFO system in the sense that we look at the priority dates. Cases are going to be processed in the order of priority date. So if they're really focused on and pushing out a lot of 2011s right now, especially in EB2, an EB3 downgrade of 2013 is not going to obviously have the same preference as far as being completed is further back in line. So, just because, yes, visas were wasted, it's very frustrating. But, at the end of the day, there's going to be even more visas available this year. Again, I know you and I have spoken a lot about this, Venkat. It's up to each and every one of our listeners to also reach out to their congressperson to really express the pain points that they're having these processes delayed like this. So even though we see the issues that came up with fiscal year 21 and the wastage of the visas, we don't want to repeat that in 22 if at all possible.
Okay. Yeah, hopefully it means we know that this year, fiscal year 2022, around maybe 100,000, between 100 to 150,000 numbers are going to be added for employment-based green card. And we'll see. This year may be very positive way to get most of the applicants will get the GCs, and anyway, USCIS have the numbers. Maybe they will try to improve the process and faster educate process for.
Well,
so
yeah, they should. I don't mean to interrupt, but they should have some process in here to have a stopgap to fix this issue, so nothing's wasted. And if that's done, I mean, we're talking about visas being priority dates being current all the way up to maybe 2016. If these visas are not wasted, especially for these backlogs with China and India.
Yeah. So here I have a scenario, Lucas, about the GC. So one, the 485 applicant applied in 2009. He got he got the EAD. Still he is on EAD, maybe around 11 years and 12 years of EAD. But last year we observed who applied in October 2020 and they got their priority date in 2012 and 2013. They got the EAD GC, but the person who applied in 2009 still on EAD, he did not get the GC. But in this scenario, do you suggest is any steps, is any process, maybe how he can react actually? So his priority date is 2009, but still he's on EAD. Is there any way to contact to USCIS and hey, my priority date is 2009. Maybe you can have a look my application and possible issue the green card or something?
I mean, it's possible if something like that's actually happening. Obviously, you want to work with your attorney and figure out what's going on. Maybe there's some type of security background check or something like this that's still pending. Maybe there's something that happened with the petitioner where they have some legal issue or some investigation with USCIS or Homeland Security or something like that. If everything is there and there's not really any underlying problem, maybe you could file a lawsuit in federal district court, mandamus action, forcing the hand of USCIS to speed up the processing of this case. Obviously, if you have a priority date going back to 2009, and you have people at 2011 right now receiving GCs, I mean, that's a pretty big gap of 2 years, if that's really the case.
Yeah. Okay. So now, it means we can still. It means we can go for the H4 and H4 application and H4 EAD. So I think still is it means the process, the too delay. It means you are saying I think you said that you are working on litigations, right?
Mm-hmm.
So apart from this, did you see any improvement on H4 application and H4 EAD? It still is slow. Is a slow process, or did you see any little bit better than previous time?
So our strategy has been to file individual cases. It's really to help benefit the individual rather than anything correcting a systemic problem within USCIS. You and I spoke about this going back earlier this year. There was another lawsuit filed that suspended the biometrics requirement for H4 and L2 EAD processes for 2 years. And we thought, well, that's great news. This is going to speed up the process. Everything's going to go back to the way it was, so on and so forth. But really what we've seen is, more of the same issues. If anything, we've seen even more delay now. We keep hearing from USCIS that they're going to address these issues, that customer service is paramount, that, all these things are going to be done. And, these actions are going to be taken to improve the overall experience and processes that one could experience while filing their case. And, we haven't seen any positive improvements. And what we've had to do at the end of the day is we just file individually these mandamus actions. And the way our theory or strategies worked is when we file these cases, the government is actually coordinating with us or helping us to say, hey, look, this case is approved. Let's dismiss the lawsuit now. And they act as liaison to USCIS. So we actually, when we file a case, the opposing party is represented by the assistant U.S. attorney in the district where we file. And then, most of the time they'll work. They have a direct line of communication where they can, reach out to USCIS to resolve whatever issue there is, and then have the case approved.
Okay. So let's come to the GC process, and also one point I want to discuss with you about the reconciliation bill, infrastructure reconciliation bill. Yeah, pretty much we saw that the immigration provisions did not add into the reconciliation bill. So as it means, we are discussing since last year. It means from last year, Biden will bring the comprehensive immigration process. Even we saw the couple of bills pending in House and Senate, and so most of the applicants are hope on this reconciliation bill, but unfortunately did not get through. So do you see any process or maybe comprehensive immigration will come up in next maybe next couple of months or 3 months or next couple of years, coming years?
I really hope so. I've been really saddened to see the state of current affairs. The issues we have now, the division in our country, the division in politics, in Congress, it has really been something that's impacted every American, every immigrant, every non-immigrant. And I don't know. I was optimistic and hoped that things would become better. In fact, what we've seen is things, again, becoming worse than what they were, even with the previous president in office. I hear a lot of Democrats say that, their focus is to help people and to do reform, but I actually think that, unfortunately, it looks like it's business as usual. I mean, I don't see the president here really making things a priority involving immigration. The opportunities there. We've seen this reconciliation package. We've seen all these things and people trying to, earmark or include things that benefit them or their constituents. And, unfortunately, I don't know why there's been such an issue with it. I mean, again, at the end of the day, we have to, alert our representatives and let them know how important these issues are. And I'm just going to go ahead and list off some of these issues, right? We have immigration backlog with India, employment base. That needs to be fixed. We have the wastage of any visas that might not be used each fiscal year. That's something that can be fixed. We have issues for children aging out. Okay, you come here, you have a 2-year-old kid. By the time you have GC, if your kid's 18, there's probability they might not be able to get GC with you. And then they have this burden of waiting another lifetime for GC. We have all these issues that impact all of our listeners day to day. And until people know the pain points that people experience, how nothing will be fixed. It's just like H4 EAD, L2 EAD delays. What about, modifying something? If there is going to be processing delays and there's a valid reason for the delay in this, why don't we change the policy or change the where people can work on the receipt notices, much like GC EAD? Why not make some adjustment like that? We really have to, use our voices here and let people know, like, hey, this is great. Everything's fine up to this point, but there's a lot of problems that are also associated with this process.
Yeah, true. It means if you see the clear about the employment based, it means I can say is unlucky persons. Whenever the bills come up in Senate and House, always tied up with the DACA and employment based. So when it comes to the DACA, the number is 8 million immigrants, non-immigrants. It is illegal to convert to the legal. So many questions come up on that one. So that ultimately employment based, they are paying taxes and they are legally staying in the United States, but employment-based immigration system did not get a right path to get the ultimate GC green card process permanent resident.
I know I hear this a lot. I just want to make one statement. I know there's a lot of usage of the term, illegal or legal or things like that. We don't want to have one side negatively impact another side. Everyone's all on the same side. The whole system as a whole should be fixed. Yes, some groups might get more attention than others, but we shouldn't look at other people and their circumstances in life and judge compared to us. Yes, a lot of our employment immigration friends going through this process pay a lot of taxes. They're key to our infrastructure, to our software development, to a lot of the advanced degrees, STEM jobs we have. But at the same time, we should focus on everything as a whole. It shouldn't, if something does pass for employment base, but doesn't pass for the DACA, we shouldn't be happy in the sense that one side received and the other side didn't. Everyone should be invested in the sense of what can we do to fix this problem, or what's the best process to address these pain points so that no one else experiences this again. That's I think the main goal. And I think if we as a collective whole voice our opinion this way, I think that's the best way of moving forward.
Yeah, definitely we will hope the process will process improvement in future. So yeah, we'll see on that one. And Lucas, I have a couple of questions on GCEAD. Mm-hmm. Nowadays, I see the last couple of weeks and the last couple of months, most of the applicants are getting the GCEADs. The question is, if any applicant have still H1 petition for the 2 to 3 years validity, if they want to use, how they can use? Already, I think we already discussed, but still, everyone got confused. There is no the right path. It means, hey, we can use this one and we can come back up. Maybe I can go to the deep the question wise. Let's say if let's say I take example, I got an EAD. So even at the same time, I do have the H1 for the 2 years of validity. Right. So if I want to go to the GCEAD, what is the process? If I want to use the,
if you're with the same employer, your employer can withdraw your H1 and simply issue a new I-9 with your GCEAD. That's one method. You could depart and re-enter the United States. There's a few different options there. I mean,
okay, you mentioned at one point is the same employer. If we want to use the GCEAD, should employee withdraw the current H1, or
employer would be doing this. So as long as your H1B is active, you're going to have to meet the prevailing wage requirements. You're going to have to do certain things to make sure you meet the regulations associated with that, so you maintain status. If you want to transition to GCEAD, obviously you won't be able to do so let's say to meet a specialty occupation, you have to meet certain requirements. We all know this, the SOC code, your prevailing wage, things like this. If you want to go and have a job in some unrelated field or something like that, or if you want to have some other role or something unique or different, I mean, obviously you would have to use your GCEAD in that regard. You wouldn't be able to rely on your H1 at that point because you're not meeting that criteria, right?
Okay. So here, it means a couple of questions on this one. Let's say, if it means, let's say I will utilize, it means I want to use the GCEAD. Later, I decided, hey, I don't want to on GCEAD. I come back to the H1. So I do have the approved H1 for next 2 years. So after 6 months or after 1 year of usage of EAD, after that, can I come back to the H1? Or in this process, should we apply the H1 petition again, or just to go to the consulate and get the stamp and come back to the United States on H1? Which process we can follow the both, or?
I mean, I just think what you have to understand is there's two processes happening at one time, right? You have a non-immigrant visa, which would be like a F1, a H1B, a L1, and then you have your immigrant visa, which would be your GC processing, right? Your EB2 or EB3, whatever it might be. Now, H1B, you can have, obviously you can have a dual intent, which would allow you to have both a non-immigrant intent or an immigrant intent, which means you can file, your GC and everything while you're on H1B. Now, you can always, while you have your GC EAD, you can always move forward and work while your application's pending, as long as your GC EAD is valid. The risk with that would be if something were to happen to your underlying petition or application, that, if something happened, then you would not be in, if the I-140 was rejected for any reason, or your 485 was rejected for any reason, you would automatically lose your EAD at that point upon the denial of that case. So at that point, you'd have to worry about, hey, can I go back to my H-1B status, so on and so forth. So it's a case-by-case basis. I don't want to stand here and give any advice that people rely on without knowing the specifics of their situation, because if I tell everyone, hey, just go ahead and quit your H1 and work on GCEAD, that's not something we should promote or request everyone to do. It's a case-by-case basis. You'd want to review all of your circumstances and see what works best for you. What are the outcomes? Are you working for full-time for a Fortune 100 company? Are you working for a consultancy company where maybe the owners had a lot of issues in the past? I mean, with DOL, with USCIS, I mean, what are they not making much of a profit? I mean, these are all things you really have to consider and look at, what your risk level is. That's what I would recommend, and then just look at case by case.
Okay. So can you suggest, Edmonds, if anyone want to use the GCEAD, maybe can you suggest to reach out to their attorneys and before use the GCEAD?
Correct. That's what I would recommend. And also remember this too, if it helps you importing your job, so once your I-140 is approved, and once your EAD, or I'm sorry, your GC is pending, your adjustment status is pending for more than 6 months, you can port to a different company. So if you're with a consultancy and you want to go full time, well, you can do that after the 6 months has passed. And your new company, you can port over with just the EAD itself. And the new company can file a supplement J when it comes time closer for your processing of your GC. That's all feasible. But what you need to do is make sure you have your plan in place for anything you do. Immigration is much like estate planning or tax preparation, right? You have to plan. You just can't say this happened. My neighbor did this. I'm going to do the same thing. You can have completely different scenarios that impact people in completely different ways.
Okay. So, and I have another question on GCEAD utilization. Let's say the primary applicant and the wife and husband. The husband is a primary applicant and wife is a derivative. So both got GCEAD. So the derivative want to use the GCEAD, maybe though the primary applicant is still on H1 non-immigrant status, will it be possible to use the derivative use the GCEAD?
Of course. Yeah. Why not?
Okay, just it means just we are trying to know is any terms and condition. Hey, the once maybe derivative will activated once the primary applicant started to using.
No, once it's issued to you, you can use it. That's not a problem. The only thing I can, go back to just tell people as far as like common issues is, let's say 5 years from now, after you have GC, you want to go ahead and apply for citizenship. Well, a question might come up saying, "Oh, I see Company A sponsored you for your green card, and it looks like here you stopped working for the company the same day or a month before you got your green card. Why is that? Why did your company sponsor you, but you never worked there?" That's the question that might come up. That's something to be prepared for. It's not to say you have to work for your company. We don't have laws here in the United States saying you have to work or stay with someone for so long. I mean, that kind of goes against everything we stand for in this country now.
Okay.
We don't want indentured servitude. So the only thing you have to be careful about is maintaining your non-immigrant status in case of an emergency, and then also, you want to show good faith that you work for the same employer that sponsored you when it comes time for GC.
So you mean to say it means after issuing the green card, permanent resident card, but USCIS will monitor the candidate. It means the applicant whether he's following the guidelines of USCIS or will come up later and scrutinize this applicant.
So when you apply for your citizenship, they're going to look at your employment history.
Okay.
And whenever you look at the employment history, it's going to be just like your criminal history. If there's anything there, they're going to want to know, who, what, where, when, why, how, right?
Okay.
And the same thing for employment. So it doesn't mean that you'll be disqualified from being a citizen. But, I mean, most of the time this might come up like, let's say you're not from India. Let's say you're from England. And you can file for someone now. The visa date, the priority dates are current. So let's say I hire someone from England, and I bring them over here, and as soon as their foot touches American soil, they already have their green card. And as soon as they get here, they never work for me. They did make a decision. I don't want to work here. I don't like doing this. Well, when they go for citizenship, the question is going to come up and say like, well, why did this law firm sponsor you, but you never work at the law firm? And then that might raise questions about, what was the true meaning or intention of coming here under this pretense. Most of the time, you don't see that if you're on H-1 because you're working for your employer already. But it does. It's not. That will never disqualify you for being applying for citizenship or becoming citizen. It's just a question that will arise. The officer usually says, I see here that you work for Company A, but I don't see any W-2s here after you got your green card. Can you tell me why? That's usually the extent of what goes on with that.
Okay. So, Lucas, we got one question from YouTube, from Mike Sams. So if candidate is working for a very reputed consulting company like Accenture, Deloitte, PwC, is it safe to use GCEAD and give up H-1B?
It's probably safe, especially if you're, hopefully this year that all the dates progress and we get, the everything moving. The issue is this: a lot of people fell into this category in 2007 or 2008, where they were allowed to go ahead and just file for GC and get the GCEAD. But then there was an issue where, the dates retrogressed, and it wasn't until maybe a year ago or 2 years ago before they got the GC. So there was a gap of maybe 8 to 10 years where someone's waiting on EAD. And the risk is, if anything were to come up with the underlying applications during that time, you could jeopardize everything that you have here, your job or your career, your family, everything could be jeopardized. So it's kind of like a bet. If you go through that route, we're betting that you're going to have your green card in hand sooner rather than later. And if that's the case, if that's the plan and everything works great, then there's no issue. But what if, as attorneys, we always have to bring up all the negatives. So what if there's something comes up and there's huge retrogression and, you downgraded with a 2013 priority date, and then now we're waiting 5 or 6 years more for the dates to become current. What if that happens? That's why I would like to just say it's key to discuss these options with your attorney so they know your specific situation rather than just giving you a blank answer of saying, hey, everyone, let's do this. Let's all quit tomorrow and use EAD. That's probably not the most responsible thing to do.
Yeah, that's right, because better to reach out to attorney in respect to attorney and get suggestion from. So immigration is a very complicated process. It means we don't know the 100% rules and policies. Better to reach out to attorney and get more information and maybe can use based on the scenario. That is a good approach. So yeah, Lucas, maybe we can take one question and we can wrap up the show.
Sure.
So yeah, Lucas, this question about the biometric, we know that who applied in October 2020, still most of the applicant did not receive the biometric schedules. So is there any way or maybe get biometric schedule?
Well, yes, actually, that's a good point. We've been filing a lot of H4 EAD mandamus lawsuits, and we were actually thinking about exploring a case study. Maybe trying 1 or 2 cases with GC EAD processing delays. So, if anyone's interested, if they want to speak to us more in detail about the process of what we might do or what we can, where we stand with everything. If you haven't received your biometrics yet and you feel that there's been huge delay, maybe you could reach out to us either through Telugu NRI Radio or directly to our email, which is on the screen here at info@bgmlaw.com. And I'd be interested maybe just speaking to you directly, privately offline.
Okay. I think, yeah, this is the most the important question for this week. Maybe you can share if anything else.
Yeah, I mean, I appreciate everyone coming back. I know we had a hiatus for a couple of weeks. Again, this program, this platform is for the community. I'd like to express our gratitude and thanks for everyone who participates or has questions. As always, you're welcome to contact our office for further information, or if you have any key points or ideas or topics we want to discuss in the future, please message us on Facebook or let Venkat know, and we'd be more than happy to discuss that. And always, if anyone wants to participate, this is an open platform, and any information you share or provide from your point of view is, I can guarantee that someone else probably has the same experience and it would help them as well. So we appreciate that.
Yeah. Thank you, Lucas. And thanks, Ramesh and Mike, for your questions. And so we are encouraging to everyone to participate in this show, and we open for conference call. Maybe you can directly connect to the conference call. You can directly talk with Lucas. And also, you can post any topic, any question on Facebook, YouTube, and Telugu NRI platform. We will address, or maybe you can directly reach out to Lucas, info@bgmlaw.com. So we are ready to help to you, and don't hesitate. And this is the free consultation. So Lucas is a nice person. So Lucas is doing the free consultation. Don't hesitate if you have any kind of immigration scenario questions and doubt, just reach out to info@bgmlaw.com. Definitely, Lucas will come back and suggest any information based on your situations. So yeah, we can stop the show today, and we come back. We will come back next week, the same time and same platform, and still there. Bye. Good evening and good night. Thank you, Lucas. Thank you very much.